license back a year and a half ago.
And how does she sign it?
She signs the word by, a colon, her initials, and then ARR. And sometimes with a commercial code number.
Can we see that?
Yes, this is not in the record. There were redacted copies that are in the record, but her actual driver's licenses were produced by her. And she testified under oath, this was her signature. She was the person who signed the statement of candidacy prior to notarization. She was the person who signed her circulator affidavits prior to notarization. So I don't think there's any doubt or any dispute that this is the individual who signed all of those documents. How she signs her name, I don't think this board gets into that issue.
Well, I'm sorry. According to something I read, that she signs it ARR. Maybe a motion. ARR. UCCI.
Yes, I think if you look at, Commissioner, if you look at her statement of candidacy, I think.
I'm gonna pull that up. Hold on a second.
What are we on, sir?
46.
It's 46 Ward, Clay.
Well, I see it on some of her petitions. By, colon, AC, ARR, UCC, 1-308, I believe, which she testified is her common style of signing her name for the last several years. We know that that's...
Can I see that paper copy? Is that the oath that's in question?
Well, this is how she signed on a petition.
So it seems as if, I'm looking at the statement of candidacy, right? This is the statement of candidacy. She says by, colon, she has a signature of her name and then adds ARRUCCI 308.
Yes. And the evidence is undisputed. That was her, and that's how she traditionally signs her name. And that's how she signs it to the Secretary of State when she gets her driver's license.
What does it mean?
Do you want me to read section 1308 of the UCC?
Is that,
Okay.
that's what's in reference to,
Yeah,
right?
it's reference section 1-308. The title is Performance or Acceptance Under Reservation of Rights. A party that, with explicit reservation of rights, performs or promises performance or assents to performance in a manner demanded or offered by the other party does not thereby prejudice the rights reserved. So this would be if you were signing a contract, but you already explicitly reserved rights under that contract. Your signature does not waive that reservation of rights. For whatever reason.
Somewhat irrelevant to a statement of candidacy form, but she did it nonetheless.
If you were a contractor, maybe you signed this way, but I don't understand it here, but that's what she does.
And I would add that under oath, the candidate did testify this is her traditional signature that she has used for the past several years. I think the board's original voter registration card does not have it, but that she testified a few years ago she changed her signature to this one.
Testify why?
Pardon?
She said signature. Did she say why?
As I recall, that she's developed a practice where she's concerned about giving up rights, and so she signs things that way, as she did with the Secretary of State for her driver's license. I think if you look at all documents that she signed, this is how she signs everything for the last several years.
I noticed on the intake receipt from when she filed the nomination papers, she signed it that way just on the intake receipt. And that's not even a contract, it's nothing other than.
Can I bring before you something that I know from my knowledge of this, and that there seems to be circulating amongst many people that if you put ARR, all rights reserved, and then UCC /308, you somehow can get out of a lot of things. There are individuals who, if you're pulled over for speeding and the officer gives you the ticket to sign, will sign that on the ticket, which has absolutely no meaning because UCC only applies to contracts.
Commercial transactions. yeah.
Commercial contracts. So there seems to be circulating out there this feeling that if you sign something, otherwise you're waiving all of your rights. It's just what's going on out there.
Are there any
No.
questions? Let's move on, Mr. Kalov, on with the other issues that, you said you wanted to make some certain clarifications and address certain issues, other issues.
So, forgive me for a moment.
Oh, go right ahead, take your time. Well, let me ask Mr. Lasker one question with regards to the objectors rule 20 motion, where he claims that the candidate changed addresses and prior to November 26th, her driver's license showed North Hazel Avenue on, as of November 26th. It's 841 West Windsor Avenue. What is there?
There are some circulation issues, but, her statement of candidacy form has been expressly modified. It doesn't just say, I live at such and such address. She pointed out, I reside at 841 West Windsor Avenue, that for more than the immediate preceding 10 years, and until November 20th, 2018, I resided at 45. So it's clearly, she's not trying to hide this fact that she's moved. It certainly is, if you're running for office, I'd say it gets complicated if you're gonna have to move in the official circulation / filing time, period, but, I think that, if I'm understanding the case, Mr. Finko may have raised objections in regards to what she's put as her address on circulation sheets, and as to what time the sheet was circulated as compared to what address it has on it. I think that it's that coupled with the statement of candidacy form, where she's very clearly informing the public, or at least the election authority, as to both addresses that she could be affiliated with. I don't think there's any fraud going on with that. That's my opinion on that.
May I expand on that?
Sure.
Because the record is very clear that, as I think every election lawyer in this room would understand, if your client talked to you at different points, you might give different advice. I have run into the situation of clients who move after filing and have handled that administratively. This client, with a 90-day period, moved approximately on the 80th day, and then the attorney was consulted. And the record is very clear, including a email trail to say, let's just be candid, let's tell the truth. And what the truth is, and the record is undisputed, is every voter who signed for the candidate showing her heading as the Hazel address, it was true on the day the voter signed it. Every notary for the circulators, where she showed a different address after she moved, it was true on the day she signed it. Her statement of candidacy was true on the day she signed it. So we tried, and as Mr. Lasker points out, we made no attempt to hide the fact. We simply said, and this is two different buildings, one's around the corner from the other. We simply said, this is what happened. We're in the same ward, we're in the same precinct, and she moved. There's still a uniform heading, which is what the lawyer was concerned about. Had we continued to collect signatures, so they stopped. Again, the record is clear as to those facts. Ms. Clay testified under oath that all signatures were collected prior to her move. I also want to add, part of the problem of the objector's position here is he keeps throwing it on the candidate to prove things. It is his burden. And when he says in his paragraph 1 in the statement, his Rule 20, other than a lease and a heavily redacted driver's license, well, first of all, yes, there is a lease that shows she moved. and where she moved to. 2, there was a driver's license, it wasn't redacted at all, and shows where she's lived. 3, there is her Federal Reserve Bank pay stub from November 1st through November 15th, 2018, showing her address at Hazel. And there was her November 16th to November 30th pay stub from Federal Reserve Bank showing her address at Windsor. There was that change on those dates. So everything is corroborated, and I think the frustration from the hearing officer is this basic theme of, Mr. Finkel, what do you have? Show me something, show some doubt here, and we'll dig into it. And with all due respect, the objector's position has been, I get to call everyone in. This is a shotgun on notaries. I get to call them all in and just question them without any showing of a impropriety. If you look at the subpoena request, which this board already handled, all it said is, I need a subpoena because I can't make them come to the hearing without a subpoena. That's not a reason. Where was the so-called information and belief to rely upon to raise the question? I believe the hearing officer ultimately did get pretty frustrated with that position and said, that's all you got, we're done. And I'm happy to answer any other questions on the other issues.
Well, any further
Joe, I
questions?
just have, this question about the uptown, I don't know, did we address the uptown issue?
The person who signed their address is Uptown.
The uptown issue.
Right, and certainly that, I would say it's not an easy burden, it's not a fair burden on an objector to say, oh, the signature is on somebody else's page as a signer. But that's not the test. As Mr. Lasker explained a minute ago, the precedents in those cases are, if the Board of Elections can find the person's address in anywhere in the nomination papers, that suffices. I would add, the outcome is not determinative, this issue is not determinative of the outcome. The candidate was on the ballot by far more signatures. But I believe the law and the hearing officer, in his opinion, cites to Sakonal, S-A-K-O-N-Y-L, to the Connor, Reese-Holmes, C-O-N-N-E-R, V-H-O-L-M-E-S cases, and also did his own research to suggest that Nader versus State Board of Elections, 345 ILAP 335, also says it's not the job of anyone else except the objector to come forward with evidence. And despite many opportunities, the objector never came forward with any irregularities.
Any further questions? If there are none, my recommendation would be to deny the objector's Rule 20 motion and adopt the hearing officer's report and recommendations. Is there a motion?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes, and the name of Angela Clay shall be printed on the ballot for the general municipal election. Thank you so much.
Thank you.
You can leave now, Mr. Finkel.
I
gotta wait.
I've got ALD 93.
Oh, okay, well, then, see you soon.
I'll see you in 4 years.
We're gonna just take a 1-minute break.
It's gonna take me longer than that to go
Do you
through.
wanna, just sign it, or? The next Rule 20 case is Jessica Santiago versus Angie Gonzalez, candidate for alderman of the 26th Ward, 19 EB ALD-093. Mr. Finkel, you have the Rule 20?
Yes. 1 second.
Sure.
So this is one where I didn't formally write a Rule 20 because of the, I think, was it yesterday or day before the decision came out, and then yesterday I was actually out of town all day, so, but Mr. Lasker allowed us to be heard by the board.
Okay.
This is not one of those cases, is it? I'm looking at a recommendation that was served on the 23rd at 6:48 PM. Is this one of those cases?
This was, we were at a hearing just on Wednesday.
Mhm. Yeah, the hearing terminated Wednesday. Ms. Osfeld, it was somewhere around 7 PM, she issued her,
Yeah.
on the same day, issued her recommended.
I remember there being one that was at 7:19, and I expressly said,
Yep.
well, it's 19 minutes late, but this one is
Yep.
that the?
This is the one that you said that we would have a waiver of the Rule 20.
When I came downstairs, I said if the report didn't come in time.
Oh.
And there was one that was served at 7:19, and I believe it was with,
That was a, I don't recall which one, but yeah, that was, I remember your comment on that. But I thought this was one as well, that you said that don't worry about it because we're having this hearing today, which, again, Ms. Oswald was writing it literally at some point in the evening, but you said that we didn't have to formally write a rule.
well, I was,
One.
I was saying that if she, because this was while the hearing was still going on, I didn't know how long it was gonna last, and I didn't know if Ms. Ostfeld would be able to get her recommendation in on time that evening, which it appears in this case she did.
Okay.
What are the issues you wanna raise?
There's a couple of issues. One is that, because of the late date for the evidentiary hearing on Wednesday, and then the time crunch, basically, that was imposed on the hearing examiner to have not only the evidentiary hearing completed, but then a recommendation written almost immediately afterwards. I was not able to fully develop the case. I wanted to have the candidate further testify, and Ms. Oswald said for the sake of expediency, she would not testify. The candidate's testimony is very relevant because the candidate knows every one of the affiants and personally was present when each of the affiants signed the affidavit to rehabilitate the signatures. And the issue here was that there were 14 affidavits that were rejected by Ms. Osfeld simply because the signature on the affidavit did not have a resemblance to the signature on the voter registration card. So, and that was the situation, I think, where there is no evidence. There is no evidence offered regarding the manner by which the affidavits were procured, and you simply have a blank affidavit on its face, and then the hearing examiner would review that if the objector, Mr. Nally, objected to all of these. So she was looking at it from the point of view is, does the voter registration card, which in some of these situations, there were some spans of time, and then some of the folks were older, some of them were younger, so there's variances. And she did note, for example, that the millennials now, every time they sign their name, it's a wholly different signature. So it's very hard, and it's a reflection on maybe we need to update the system and how this works. But the candidate would have testified, and she did to some degree offer proof to say, yeah, I was there at all but three, I think, all but three of the affidavits. She was personally present. She watched the voter. She went to the voter's door, knocked on the door, said, can you sign? Because we've got the incumbent's challenging my paperwork, or the opponent is challenging my paperwork, and so they said your signature wasn't matching what was in the voter database, and she went and asked for affidavits from, I forget, 60, I don't remember the exact, 60 some, or 60 or 70 voters. And that we submitted all of these affidavits, and there's, sorry, 73, exhibits 1 through 73.
And
So
when did you submit that, when were those entered into evidence?
the affidavits were on Wednesday, the 3rd. They were entered into evidence, and they were presented to the hearing officer. They are in the board's file right now. So that's, and the candidate was there. She was present during this hearing. She does know these voters. She did see them sign the affidavits. So the argument that I'm presenting to the board is that the rule from the Kresse versus Romanelli case would not apply in this situation because there is extrinsic evidence to corroborate the veracity of the affidavits themselves. The affidavits are sworn testimony. It's no different than somebody coming in and testifying under oath before the board. There is no reason to doubt or deny the veracity of these affidavits, which affirm that this voter that signed, they have the petition sheet was attached to each of the affidavits. The petition sheet was presented to the voter. They reviewed the signature. They said, yes, I signed. And the voters filled out the information on each of these affidavits. There's a notary that was present. The notary asked for ID, verified the signature. This was all done proper. And there's no reason, there was no evidence offered to dispute the veracity of these affidavits. The only argument was that the signature did not match the voter registration record that was in the board's Rule 6 exam. The signature clip that was printed in the board's copy of the Rule 6 records exam. And there was, altogether, it was 14 of those. The other objection
So
was...
you're saying that these affidavits should be accepted on the face?
Yes, sir. I do say that, and because this isn't simply a naked affidavit, as it were. It's not just a cold affidavit, a piece of paper. The testimony of the candidate was added as well to say she saw all but 3 of the affiants sign their names, and she knows every one of the affiants because they are people that she went to and she's known them from the past, from other circles, from other events, from other activities. And that's what she would have testified to, and I would ask if necessary to remand this for further proceedings. She would corroborate, and she would go through each and every single affidavit. But for the urgency of the time, we were not able to do that at the evidentiary hearing. We were moving through it at a rapid pace. Argument was shortened. We didn't go through the traditional, look at the line, the signature goes below the line, the signature goes above, look at the I has a circle instead of a dot. You know, we weren't doing the traditional Romanelli, Fritchie type analysis where we're sitting for a week scrutinizing each and every signature, which I've done in the past, but that's not what we did in this situation, and perhaps fortunately, but
She did review each affidavit.
she
that's what
did.
I said.
She reviewed them, but I'm not,
Just
but
not long enough?
I was not able to present argument on majority of them. That's the thing, that I wasn't able to point out, oh, well, the first letter of the names is the same, or the middle initial is the same on all of them, and it's written with the same hand. You know, I think Ms. Oswald did a fine job, you know, given the time constraints. I'm not saying, you know, she shortchanged, you know, but she was at a brisk pace reviewing 70, 80 affidavits. So that was certainly, I think, you know, one of the issues that we're raising. And if the affidavits are accepted, I think will be, by my count, it will be 14 additional signatures that should have been allowed. Which, and this candidate certainly showed that modicum of support. She certainly has the signatures. This is not where somebody puts in 2 sheets. She had a very high validity rate, very high validity, walked door to door, and just, it was a tough ward. A lot of people were scared. It's one of those wards where the alderman does have a lot of influence. So she, you know, would have testified, yeah, there were a lot of people that were afraid to sign because they didn't want their name associated with a competing candidate. So she did the best she could. She didn't take shortcuts. She actually got valid signatures. So I would ask that those affidavits that were denied be allowed, that the candidate's name be placed upon the ballot.
Okay. Mr. Mallon?
Thank you. First thing I would like to, just for the record, note, Mr. Osfeld's recommendation was served on the parties at 6:45 p.m. on Wednesday. I emailed Mr. Finko to say, are you going to attempt to do Rule 20? He said that definitely I am, so I'm here, because I have to protect my client's interests. But I'm not sure that the rule has been complied with for Rule 20. But having said that, this is a pretty simple case. Basically, what the candidate is saying here is that affidavits should be automatically accepted to reverse the decision at the Rule 6 records examination. At the Rule 6 records examination here, the records examiner reviewed, then the handwriting expert reviewed. At the conclusion of the process, the candidate was 61 signatures down from the minimum number of signatures that she would have needed. The candidate filed, within the time allowed for Rule 8, a Rule 8 motion and appended 68 sheet and line numbers where they were, said they would seek to rehabilitate those. Then 3 days later, the candidate filed what was termed a corrected Rule 8, where the number had grown from 68 to 85 sheet and line numbers. I objected to the fact you only get one Rule 8, and that had been filed. So what Ms. Oswald did, I think, in an extreme bit of fairness, and because of the time constraint, she said, look, I'm going to look at, first of all, the original Rule 8 and the 68 names you presented to me there. I'll rule on those. Then I'm going to let you make an offer of proof on the second Rule 8 that you filed, because the time is so short. At the end of the review of the first Rule 8, in my opinion, the only legitimate Rule 8, the candidate was 24 signatures down. And the hearing officer here did what all hearing officers, in my experience, of the board do. When the presumptively correct results of the Rule 6 records exam are presented, and the burden is on the party seeking to change those, the hearing officer compared three things. She compared the signatures on the affidavit proffered by the candidate, the signature on the petition sheet involving that name, and the signature registration record that the board has in its files. She compared all three, and then she made rulings, as any finder of fact would do. And we went through that. It was not a rushed proceeding. We spent 4 or 5 hours on this. And yeah, Mr. Finkel was not allowed to argue each time about her ruling, but she's the finder of fact at that point, subject to the board. And argument is not part of the evidentiary proceeding. Argument is a separate proceeding within our overall proceeding. So the fact that she went through, and she did state on the record, I'm comparing this signature, I'm comparing this on this document, on this document, on this document, and she gave a rationale for each of her rulings. This is a math problem. On the first Rule 8, the only proper Rule 8, the candidate was 24 down. The candidate was afforded the luxury of an offer of proof on a second Rule 8, which was not, in my opinion, proper.
So the next question of the first, you said the first was 60?
There were 68, on that Rule 8, there was a list of 68 sheet and line numbers that the candidate said she wanted to bring in affidavits to prove that the signature was that of the voter.
And of those 68, how many were rehabilitated?
Well, she came out of that 24 under, so whatever the numbers would be on that.
I don't remember where she started on.
She started 61 on 37 were rehabilitated on the original
Of the
Rule 8.
68.
Of the 61, yes, of the 68.
Okay.
Then the second Rule 8, there were 85 names on the second Rule 8 that was filed. And the candidate was allowed to do an offer of proof on that and rehabilitated like 14 more or something, so that the candidate after the second Rule 8 was still down 9 signatures. So it doesn't really matter here whether the first Rule 8 or the second Rule 8, other than I think the board doesn't want to set a precedent that people can file multiple Rule 8s, because then you're really going to have problems. But the bottom line is here, no matter how you do the math, the first Rule 8, she's 24 down. The second Rule 8, she's 9 down. She's down from the minimum number of signatures.
Presumptively, because, I have to calculate it from that now. Had all of those been rehabilitated, she would have been over the number?
Yes. But that's not how it works. The argument of Canada is basically, take all these affidavits, and because I have an affidavit, change the rule. And that's not how the process works with our hearing officers. They still have to make a comparison to determine if the presumptively correct result of the records exam should be overturned for other evidence. And that's exactly what Ms. Oswald did. She looked at the petition sheet, she looked at the affidavit, she looked at the registration record signature, and then made rulings as to each one.
One further question, I think for a number of reasons, Mr. Finkel, your Rule 20 fails. I do think it's untimely. I do think, as opposed to what you say, that there is very good evidence that the hearing officer took her time to review each and every one of these signatures. For those reasons, I would recommend denying the Rule 20 and adopting the hearing officer's report and recommendation.
Yeah, just while you were arguing, I was going through and comparing the signatures on the petitions and signatures on the affidavits to those that the hearing officer overruled who did not accept. And I would agree with her on those as well. So Are you prepared for a motion?
Yeah,
May
is
I
there, yes,
just make one 2-minute statement or 1-minute statement on a couple points?
briefly.
Okay, so the Friday evening filing, it was Friday evening, shortly before 5, was sent out. And the issue came up through a technical issue because I submitted the Calderon list. There are 2 companion cases, one filed by Calderon, one by Santiago against the same candidate. Sunday morning, I said, here's the Santiago list, and I filed a motion for extension of time. Rule 8 allows for an extension of time because it says by the next day or at some other time. So I was asking in the interest of justice, because this board is here to review the sufficiency of the nomination papers, not for technicalities, not for the gotcha defaults. The question for the board is, are there sufficient valid signatures on this candidate's nomination papers? The affidavits confirm that. And then the affidavits similarly were corroborated by the testimony of the candidates, so they aren't stark affidavits in the vacuum. They are corroborated by the candidate, who also was a circulator on a majority of these sheets and would have testified that I know this person, that's the person, I recognize her from the street, that's who signed my petition sheet, and then she would have confirmed it a second time to say, I went back to her house and she signed my affidavit for me after reviewing the petition sheet. So this is the question here is are there valid signatures or not? And the affidavits confirm that there are more than ample, sufficient, valid signatures to pass muster under the election. Thank you.
Your arguments are noted for the record. At this time, is there a motion to deny the Rule 20 and adopt the hearing officer's report and recommendation?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes, and it is therefore ordered that the objections of Jessica Santiago to the nomination papers of Angie Gonzalez, candidate for alderman of the 26th Ward, are hereby sustained, and said nomination papers are declared invalid, and the name of Angie Gonzalez shall not be printed on the official ballot. Thank you.
Thank you.
I'll have the board's attention for 1 minute, totally unrelated. You're well aware that most people come here and tell you all the stuff that went wrong during the process. I just want to take a minute and make sure you're aware of how well your staff performed during this extremely, extremely time-crushed procedure. Mr. Holliday and his staff at the records exam were uniformly polite, efficient. John Powell and all the people at the hearings are fine court reporters. The hearing officers, some of whom ruled against me, but I feel very strongly that the process itself was a compliment to the board and the people that you have here. And like I said, people usually come and to yell at you. I want to tell you how well all these people performed and how much it's appreciated by the election bar as well as our clients.
Thank you,
And
sir.
I'll strongly echo those comments and recommendations. I think it was a very good job by everybody here.
Yeah, we have a
Thank you.
great staff.
And Betty always had a smile and a friendly word for everybody.
That's right.
Thank you.
Thank you.
Now she'll make you some copies.
We have some final decisions, and actually a related case to the one we just heard. And that is number 5 on the agenda, Juan Calderon versus Angie Gonzalez, 19 EB ALB-048. Is there a motion to adopt the hearing officer's decision?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes. And we will proceed now to other final decisions where the objections have been overruled in the following cases. Number 1 on the agenda, Abdul Rehman Shaikh versus Zira Quadria, 19 EB ALD-014. Number 9 on the agenda, Armando Ramos versus Majid Mustafa, 19 EB ALD-062, with a related case ALD-082. Number 10 on the agenda, Grace Contreras, Michael Anthony Rodriguez, and William Anson Sr. versus Martha Yerania Rangel, 19 EB ALD-074, with a related case ALD-118. Number 13 on the agenda, Renee Elms, Peter Rivera, Renee Wozniak, Maria Orihel, and Evelyn Razo versus Otis Davis Jr., 19 EB ALD -098. Number 14 on the agenda, Nathaniel Moore versus Charles Kyle, 19 EB ALD -112. Number 15 on the agenda, Kelly Martin and Jessica Anderson versus Maya Hodari, 19 EB ALD -124, with a related case ALD 142. Number 17 on the agenda, Nathaniel Moore versus Jedediah Brown, 19 EB ALD 127. Number 18 on the agenda, Gina Zuccaro and Emma Jean Robinson versus Beverly Miles, 19 EB ALD -128. Number 20 on the agenda, Kevin Bailey versus Maya Hodari, 19 EB ALD -142, with a related case ALD -124. Number 21 on the agenda, Kevin Bailey versus Quandra B. Spites, 19 EB ALD -144. And number 22 on the list, Gina Zuccaro and Monique Cook Bay versus Peter Gariepi, 19 EB MUN -016. Is there a motion in each of these cases to adopt the respective hearing officers' reports and recommended decisions, overrule the respective objectors' petitions, and enter final decisions in favor of each of the aforementioned candidates?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes. And it is therefore ordered that the names of the respective candidates shall be printed on the ballot for the municipal general election. Is there anything else that on the list?
Yes, off the ballot. You want off the ballot?
Yes.
6, 11, 19.
It's been a long meeting.
I have it. Oh, 3, 6, 11, and 19. Okay. For some reason. Okay, the following cases, the objections have been sustained. Number 2 on the agenda, Renee Soto and Virginia J. Contreras versus Irene Corral, 19 EB ALD -024. Number 3 on the agenda, Marcel Bright and Daryl Lenoir versus Deontay Lawrence, 19 EB ALD -034, with a related case ALD -049. Number 6 on the agenda, Lily Yarber versus Deontay Lawrence, 19 EB ALD -049. Number 11 on the agenda, Jessica Santiago versus Angie Gonzalez.
We just
We
did
that one. And number 19 on the list, Kevin Bailey versus Charles Hilliard, 19 EB ALD -139. Is there a motion to approve and adopt the hearing officer's report, sustaining the objections in each of these cases?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes, and the names of each of the aforementioned candidates shall not be printed on the ballot.
Madam Chair, Commissioners, we have final decisions memorializing these events. We signed here in open session. We have
Voice.
final decisions for the commissioners to sign here in open session.
And at this time, I have not received any requests for public comment.
get to spend your Saturday in the great outdoors.
Yeah, what am I gonna do? What am I gonna do? And I have plans all around this.
Going to the country house now.
Yeah,
You know?
Riding the horse.
Exactly, right? We're gonna take the little kids for a ride.
We're gonna head out to the island. Blue Island?
It's
but-
raining in Puerto Rico, I said, too bad.
Did you tell her it's sunny here?
Yeah, I told her, oh, bright and sunny.
And stop it right there.
Yeah.
So,
They're now all summer.
Okay. At this time, we have completed all of the objections cases for the general municipal election on February 26th. I would like to thank the staff. They have performed marvelously. Thank you so much. Mr. Lasker, you have held this together, and we are so fortunate to have you.
Thank you.
Thank you so much. My fellow commissioners, thank you for everything. Mr. Holliday, Mr. Goff, thank you for everything. And so, at this time, I will entertain a motion to adjourn the Electoral Board hearing for 2019.
With thanks and gratitude to our chair, who's done magnificently as well, I so move.
Second.
All those in favor?
Aye.
We're adjourned.
Woo!